Good morning, everyone. And of course, happy Webinar Tuesday. It's great to see everybody. A friendly reminder for those who may have just joined us that this webinar is being recorded. It will ultimately be distributed to PRLA membership, to our Philadelphia chapter, and our daily update email, and posted on YouTube as well. My name is Zach Pyzik. I am PRLA's Senior Director of Public Affairs, one half of our Government Affairs Department. I want to thank you all for joining us today for what we believe is a very important conversation. Today's presentation has been organized specifically for owners and operators operating in the city of Philadelphia. If you are here today, you are likely probably familiar in some form with some of this background, and so I hope you'll forgive me. But we are here to talk about the Philadelphia Fair Workweek Ordinance, which, as I understand it, became law, I want to say, in December of 2018. I believe it was originally set to go into effect in January of 2020. And then late in 2019, I want to say the effective date was ultimately pushed back at some point. And then due to the pandemic, I know that there were, enforcement of several aspects of the ordinance did not begin exactly when they were supposed to. All that said, that's what the team here today is to discuss with all of you. For some time now, the ordinance has been in effect. And employers have certainly been expected to comply with the ordinance. The Fair Workweek law requires, as I understand it, covered employers to provide service, retail, and hospitality workers with a predictable work schedule. It also requires good faith estimates and 14 days advance notice of scheduling, along with other protections for employees. Based on some of the feedback that we've received from owners and operators in the city of Philadelphia that we represent, it's been brought to our attention that the ordinance can be challenging and administratively burdensome to comply with. Some have even said that it can be dizzying, especially with the workforce shortages that many have endured in the industry and the realities of the hospitality and tourism industry. We're joined today by some of the legal team at Jackson Lewis in Philadelphia. Jackson Lewis, they are the experts on the ordinance, and they have really seen firsthand how this can impact the industries that we represent here in Pennsylvania and Philadelphia. I want to thank the team at Jackson Lewis very much for their willingness to lead and coordinate today's webinar. Again, we believe this is a very important conversation for our membership. So without further ado, I'd like to introduce Dan Thornton of counsel, and Tim McCarthy, principal, both from Jackson Lewis. Tim and Dan, thank you both very much for joining us today. The floor is yours, and I'm happy to monitor the chat for any questions that may come in during your presentation.
Thank you, Zach. We appreciate it.
Yeah, thanks for that kind introduction, Zach. It's a pleasure to be here and to speak with some of your membership about this important ordinance. As Zach said, Tim and I both have a lot of experience with this, both in helping restaurant and hospitality clients comply, figure out how to deal with the ordinance, as well as dealing with the city and with private litigants who are trying to enforce the ordinance and working on that phase of things as well. We'll talk more about our experience with lawsuits and class actions and enforcement actions around the ordinance towards the end. But we want to start out by kind of stepping through some of the different aspects of the ordinance. I know some of the folks on this call will be more familiar with this than others, but we found a really varying level of knowledge, and I think it's helpful to at least go through everything. And we encourage you, as Zach said, to ask questions throughout. Zach will be watching the chat, and we're happy to address questions as we go. I think everyone who's paying attention has questions, because this is a complicated ordinance and it really gets into a pretty insane level of detail. So there are no stupid questions, especially dealing with this. So without further ado, I want to talk a little bit about the ordinance in general and who it covers, with a focus on who we're dealing with today. As Zach mentioned, it covers, in the city of Philadelphia, basically three industries: retail, which we're not as concerned with right now, food service establishments, which basically means restaurants, and then hospitality establishments. But it doesn't cover every employee. At a high level, the ordinance covers hourly employees who are performing frontline customer-facing work. And in particular, from the regulations, say it covers workers who are involved in the direct provision of food or hospitality services to the public. And Then it goes on and lists, several by way of example, who's included and excluded. So this includes servers. It includes anyone in a hotel establishment who's interacting directly with customers. It includes floor managers who oversee those people. It includes employees who are engaged in completing sales, like for a restaurant, that would be delivery drivers. It involves security people, so long as that involves at least occasional customer contact. So your average bouncer outside of a restaurant or bar would be covered. Hotel security, same thing. It also involves maintenance people. If they are dealing sometimes at least with responses to customer requests, they're customer facing, they're covered under the ordinance. Who it doesn't cover, though, are what it calls administrative and professional hourly employees. So this is from, I guess, non-customer facing parts of the business. So if you have an HR department, payroll department, those kinds of things, those aren't going to be covered. But anyone who deals with your customers and clients, even occasionally, in an hourly role, is going to be covered under the ordinance. And again, these terms at the top of this slide, they come right from the ordinance, and they're defined using NAICS codes. So basically, any hotel or full or partial service restaurant is going to be covered within the city. There are some numerical requirements to be covered, and this is where the definition gets a little interesting. You have to have both 30 or more locations and 250 or more total employees. But that's not just within the city, it's worldwide in the terms of the ordinance. So the goal here, what the city council is trying to hit, are all the big chains, especially ones that might just have one or a handful of locations in the city. So that's just an overview of the basics of who the ordinance covers. And with that, Tim's going to talk us through some more of the high-level details.
Thanks, Dan. So we've heard already about how this is a complicated ordinance. It can be dizzying for employers, and our job, at least today, our hope is that we can make the ordinance a little bit more understandable from a practical perspective for your frontline managers. And in order to do that, what we've done in our evaluation of the ordinance and based on our counseling of employers through the ordinance is to kind of distill the requirements under the ordinance into three primary components, three primary buckets. And then, hopefully that makes it a little bit more intuitive, a little bit more, easy to understand and implement in practice. So those three buckets of obligations under the ordinance are, first, the requirement that employers provide what are referred to as good faith estimates of work hours, which is essentially a document that should go to all covered employees, laying out hours, subsets of hours on a weekly basis when those employees can be expected to work. So all employees at this point, whether existing or new hires, should have these good faith estimates of work hours. Luckily, the city of Philadelphia, I say luckily with air quotes, but it's better than nothing. The city of Philadelphia has given us a template good faith estimate that helps out a little bit. It's not left to the employers anyway to come up with the form, but employers still need to know how to go about filling out that good faith estimate document. So we'll take a look at that. The next general requirement, is that employers provide predictable scheduling, i.e. advance notice of work schedules. So at this point in time, initially the requirement was that all work schedules be issued 10 days in advance. That is now 14 days in advance. So essentially, covered employees should be getting their work schedules at least 14 days in advance. And a corollary to that requirement is that, when there are changes to those work schedules within that 14-day period, employees may be owed what's known as predictability pay, which is essentially, a penalty for changing those posted work schedules. And then last, the other major requirement under the ordinance is that new shifts, new hours must be first offered to existing employees before you go to an external talent pool. So essentially, covered employees have to be given the right of first refusal when there are new shifts made available. And we'll get into some more specifics about all of these requirements as we move through this presentation. So we can move on to the next slide. So the first thing we're going to touch on is good faith estimates of work hours. As I mentioned, it's essentially a form that lists the subsets of hours that employees can be expected to work during a given work week. So again, all covered employees should have one now. And what's in the actual document, one of the things that we list is the average number of hours that an employee can expect to work each week over a typical 90-day period. So, it's called a good faith estimate because, employers, the intent is that employers think about this before they, write these things down and think about what we actually expect this person to work, not just, fill something out saying, they're going to work, we'll put 12 hours every day of the week or something like that. So, every potential permutation of their schedule is listed. There should be some sort of, good faith basis for whatever is listed in that good faith estimate. So in addition to that average number of hours, there's also a list of the days and times that the employee can typically be expected to work. You can also fill it out in, conversely, where you list the days and times when an employee is not scheduled to work, but that's a little complicated. So obviously we think it makes more sense to just list the days and times when the employee would actually be expected to work. And then the other thing is that the good faith estimate has to indicate whether or not the employee can expect to work any on-call shifts. So the next slide, we're going to take a look at some of these actual documents. So to the left side of your screen, you'll see the template good faith estimate of work hours that has been circulated by the city of Philadelphia. So there are a couple forms that we'll go back to and reference throughout this throughout the presentation. And one thing I must say is that the city of Philadelphia has done a decent job of putting out forms that are compliant, as well as putting together FAQs, regulation documents, the ordinance itself. All that stuff is readily available at a website that is maintained by the city of Philadelphia. So it's actually very helpful, and it's where we can find, this good faith estimate of work hours if you're looking for it. It's, essentially a Fair Workweek Ordinance resources webpage that has a database of all of these documents. And so anytime we reference a city of Philadelphia template form, they are available online on this website. So getting into it, this, you'll see the good faith estimate at the top. There's the basic employee information. It has the employee name, the effective date, whether or not the particular good faith estimate was provided upon hire or to an existing employee, and then a couple other, details about the position. And then down, further, you get into the actual estimate. So, you'll see a grid here. Monday through Sunday, all of the days of the week are covered. Start times, end times can be filled out. And it's relatively self-explanatory on the surface anyway. You'd be surprised at, how difficult this can be, in practice, especially for, first line managers whose primary job is, managing the employees and not necessarily filling out, paperwork that is not the most intuitive. So this stuff does, occasionally take some training to, in order for, first line managers in particular to, understand the importance of this and exactly, how to fill these out. On the right side of the screen, there's a, just a filled out version essentially of the good faith estimate. The one thing here on this right side, we intentionally filled this out in a way that we typically see employers do it, but in a way that is not necessarily the best way to do it. So in this example, we have the average number of hours listed each week as 25 hours. And looking at the form, you probably see it makes sense. There's 2 10-hour days and 1 5-hour day. So, the average number, there you go, 25 hours. The total hours that are listed in the grid add up to 25. Consistency, always great, makes sense. But under the ordinance, you're actually allowed to, when filling out the good faith estimate, you're allowed to have the total number of hours equal 1.5 times what the average number of hours each week that is, that's listed. So, for example, and I'm sure what I just said doesn't make any sense initially. The average number of hours that we have listed is 25. That means that when we're filling out this grid, the total number of hours can add up to 35 or 37.5, which is 1.5 times the 25, the 25 hours. And what that does is it allows employers some flexibility when scheduling within the good faith estimate. Because employees are only because this particular employee would only be working an average of 25 hours a week, by filling out this chart in a way that allows for 37.5 hours, it gives you some flexibility such that this employee is not working these exact 3 shifts every week. So there might be another day, you might make the shift, the potential shifts a little bit longer, just depending on the realities of the position. And why that's important, or helpful anyway, to do that is that, when there are significant changes to a good faith estimate, it just adds to the administrative burden, because when there are those significant changes, you have to reissue the good faith estimate. We can hop over to the next slide. So this basically, just goes through some of the things that I just mentioned. Again, the major takeaway, at least for me, when filling out these good faith estimates, is that, you keep in mind that the average number of hours that is listed should be lower than whatever the total number of hours is within that grid, so as to provide you with some more flexibility. Again, I mean, this is me explaining it, and I've been dealing with this ordinance for 4 years. I understand that, and I'm probably not explaining it great, but so I understand that this would be difficult potentially for these managers who have to actually fill these documents out. So having training with these managers is always helpful, and kind of working through the first batch of good faith estimates with managers is always a helpful thing to do. And in reference to that form, this is another theme that will come up throughout the presentation. Essentially, under the ordinance, for enforcement actions and for private rights of actions, i.e. lawsuits over this ordinance, there's a 2-year statute of limitations. So essentially, all documents relating to good faith estimates, schedule changes, predictability pay, all that stuff should be retained for a minimum of 2 years. And it's a lot, because the ordinance imposes many obligations. It's obviously quite the burden to keep every time there's keep documents for 2 years every time there's a change to a good faith estimate, or a minor change to a schedule. But again, just as if you take nothing away from today other than these records should be retained, that is helpful. There should be records every time you take a step to be in compliance with the ordinance, whether it be filling out good faith estimates, changing schedules, paying predictability pay, offering new shifts, things like that. Record keeping is very important, because essentially there's no other way to show compliance, really, other than keeping those records. So with that, Dan, I think you're going to get us into the scheduling requirements and predictability pay.
Yeah, absolutely. So this is that second bucket we talked about at the beginning. And this is one of the trickiest to deal with, the advance notice of schedules. And as Tim outlined at the beginning, during the initial kind of period of implementation of the ordinance, there was a 10-day advance notice requirement. It's now 14 days. And the basic requirement is for employers to plan, finalize, and post schedules at least 14 days in advance. There's not one format you have to do it in, but generally speaking, it should either be provided electronically, if it's your practice to communicate schedule changes to employees electronically, or if you have a timekeeping or scheduling system that does that, electronic notice is fine. But otherwise, it should be posted in a conspicuous location within the establishment, or both. And it's important every time the schedule's posted that it be time-stamped with the date and time that it's posted. That's important for several reasons, but mainly to demonstrate compliance. Should there be a complaint, should there be an investigation by the city, or should there be other kind of legal action, because without the schedule documents themselves and timestamps showing when they're posted, it is difficult, if not impossible, to establish compliance with this requirement. And similar to the other documents that Tim talked about, the good faith estimates and revisions to those, everything here should be kept for 2 years because, again, 2 years is the statute of limitations for the ordinance. So schedules should be consistent with those good faith estimates. That's the GFE abbreviation you see in the second bullet. The hours that are posted should be consistent with those that are in the good faith estimates. We can talk a little more about what happens when that's not the case. But continuing here for now, you got to post 14 days in advance, but that's not the final be all end all schedule. There's a 24-hour grace period after the posting for going back and forth with employees, for finalizing, shift swaps, changes, that kind of thing. And then reposting essentially within 24 hours of that 14-day advance deadline. So essentially it's a 13-day deadline then. You repost the schedule with any of those changes. After that, employees under the ordinance have a right to refuse any changes to the posted schedule. So it's a huge headache for employers trying to make changes within that window in a manner that's compliant with the ordinance, because this really has shifted the balance of power, and it gives employees really everything, and it makes frontline managers, as Tim and I have seen this, they're pulling their hair out begging people to fill shifts or make changes when they happen kind of after that 14, really 13-day advance requirement. But employee consent is required if you make additional changes after the schedule's been posted and finalized. And we'll get a little more into the details of that. And there's also a form for indicating consent, because just texting with employees, as we often see, that's fine, but that's not enough. You need to have something in writing. And unless you want all of your managers' text messages to be discoverable during litigation or an investigation by the city, it's best to fill out forms when these changes happen, within the notice period. A related requirement is that the ordinance prohibits employees from being required to work 2 shifts in a row where there's less than a 9-hour break between the shifts. It's called a requirement for rest time. And employees can, again, consent to that. It's not a violation of the ordinance if they consent, but they're supposed to be paid a $40 wage enhancement in cases where they do have shifts close together and they do consent to the change. If we could turn to the next slide. We'll talk about the predictability pay, which is really the penalty for changes that are made after that notice deadline. One other requirement is you have the 14-day requirement, right? You got a 24-hour grace period after that to make any final last-minute changes to get what's ideally the final schedule posted by essentially 13 days before. Any employer-initiated changes after that are supposed to be reflected within 24 hours per the ordinance. So what does that mean? Posting the schedule yet again, circulating it to employees electronically yet again, if that's the manner you do it. And furthermore, when employer-initiated changes happen within this notice period, employees are entitled to what's called predictability pay. And there's several flavors of this that we have listed in the bullet points. So it's pay at their regular rate. For tipped employees, it's a little more complicated. There's some guidance on the city's site and some determinations as to what those wage rates are. But for your average employee, it's their regular rate of pay. And when they have hours added or a new shift added, they're supposed to receive a 1-hour pay enhancement. If the shift is otherwise changed, the hours are the same, but the date, the time, or the location change, also an hour of pay. And if a shift is canceled or shortened, it's half of the employee's rate of pay per hour. So if an 8-hour shift is shortened to 4 hours, the employee would be entitled to half of that 4 hours of pay, or in other words, 2 hours of the employee's regular rate of pay. There are a number of exceptions to this, though, which we'll look at in the next slide. So employee consent like with most aspects of the ordinance we've been talking about, is an exception. With the employees agreement, you can do, almost anything. Sometimes you'll still owe some money, like for those shifts that are scheduled with less than a 9-hour rest period in between. But where the employee requests a change, to employees want to trade shifts, or employee wants to go on leave, whatever it is, you don't have to pay predictability pay in that case. Similarly, if additional hours come up that are not reflected on that final schedule, and you use a mass communication, meaning like an email blast or a message sent through your timekeeping or scheduling system to all employees, and an employee volunteers for those additional hours, that's not going to incur any predictability pay obligation either. The start times and end times of a shift can vary by up to 20 minutes without incurring this penalty. If it's more than that, though, then that halftime obligation does come into effect. Similarly, there's kind of a force majeure provision. If there's an emergent condition that prevents opening or from employees working their shifts, there's no obligation in those cases. Terminated employees can't claim predictability pay. Similarly, if there are disciplinary reasons, like a multi-day suspension or some other reason why an employee was going to work but is not, that is disciplinary in nature, there's not going to be a predictability pay obligation there. But it's important to document the discipline. And this reflects on a larger theme we talk about in all kinds of cases. Whenever there's a significant discipline, please document it and keep the documentation consistent. We can have a whole separate session on how to discipline and how to write effective documentation, but we'll move on from that for now. And then I think on this next slide, we're going to turn back to Tim to talk about the city's forms for mass communication.
Yeah, sure. Thanks, Dan. As Dan just mentioned, one of the exceptions to the general predictability pay requirement is if employers use what's referred to as a mass communication. And essentially, it's a way for employers to fill open shifts. And this is for a one-off situation, not a situation where there's, an employee who leaves and then, you need to fill that shift on a go-forward basis. This is a situation where, an employee calls out or something like that, or, for whatever reason, you need to fill a shift. And you can use this mass communication as a way to, essentially not have to pay predictability pay. In practice, it's typically not the most efficient way to do things. And, the employers that I've talked to, they've tried doing it once or twice and, it doesn't always work. So with the mass communication, essentially you have to you can use this form, you can send the same information via text message to, eligible employees. But this is the general information that you need to provide in this mass communication. And in order for it to qualify as a mass communication, it essentially has to go to all employees eligible to work that shift. And it's not a situation where, you send a text message to 2 employees and say, hey, Dan and Zach, can one of you guys fill in, for this shift? We need somebody to work. That's not a mass communication. A mass communication is, an untargeted text message or, document, email, whatever is the typical method for communication to all eligible employees who are eligible to work that shift. And, if you do that, essentially, you don't have to pay predictability. A lot of times it may just be easier to, ask, you may have to, for practical purposes, reach out to specific employees and say, hey, will one of you guys work this shift? If that does happen, you'll have to pay predictability pay. The employee can't be required to work the shift. You'll still have to get, written consent. But, as a practical matter, managers know their employees. They know who may be more likely to accept a shift, who may be less likely to take a shift. But this is an option. So that's kind of why we are, raising it. And again, just highlighting the fact that there is this template document available through the city of Philadelphia. And right at the bottom, again, they're reminding employers that, this record should be kept for 2 years. We can go to the next slide. So when schedule changes are needed, and we've touched on this, quite a bit already, the biggest thing is that whenever there is an employer-initiated change and we're having an employee change their shift or a new employee work their shift, whatever it may be, you want to get written consent. If if the employer knows that there's going to be a need for a schedule change, the employee should be notified immediately. This kind of goes without saying, but you should get written consent before the change takes effect, not after. Not after you ask an employee to work a shift and then they work the shift and then you get the consent after the fact. Consent should be done before the change takes effect. Employees can't be required to work shifts that are not on their posted work schedule. So essentially, employees have the right to refuse additional work hours. The other thing is, anytime there's a change to the posted work schedule, you have to provide a revised work schedule in writing as soon as practicable. So even if there's a 1 hour change to one employee shift, that entire posted work schedule, theoretically anyway, should be recirculated as an entirely new schedule to the entire workforce, not just to that one employee. And similarly, employees can't be required to find coverage for shifts they can't work. Conversely, employees, if they find, and this is another exception to owing predictability pay, if an employee initiates a change and swaps their shift with somebody else, predictability pay is not required. If there's a shift swap between employees, it's not an employer initiated change, no predictability pay is owed. But employees can't be required to find coverage for shifts that they can't work. We could head over to the next one. Thank you. Here's another form issued by the City of Philadelphia. This is a template schedule change consent form. This is one that I think is helpful. It includes a little chart there for calculating predictability pay depending on what the changes are that are being made. This is, it's a relatively intuitive form. I have seen employers come up with their own forms and tweak this and, not necessarily include a blurb of what the statute says. But this is a helpful form. It's available on the City of Philadelphia's website. It should be kept for a period of 2 years. This one I think is actually pretty self-explanatory. Obviously, if there are any questions on this one, let us know. But the main takeaway here is that this is not something that you need to come up with on your own. This form is out there, but this should be signed by employers or by employees and the managers prior to any employer-initiated schedule change taking place. We can head over to the next one. Thank you. All right, so now we've covered good faith estimates and predictable scheduling along with predictability pay. So the third major requirement under the ordinance is that existing employees be offered new work shifts before hiring from any external talent pool. Going back to the city's available forms. Just a quick note here as to the offering of new shifts. The ordinance requires that employers have a written policy that is distributed to all employees that details how employers will go about offering new shifts to existing employees. And, it doesn't need to be a very long policy. We've worked on a number of templates for employers in Philadelphia. 2 or 3 pages is essentially what this policy typically adds up to being, but it does need to be in writing. You need to explain the procedure for, who is chosen, how are jobs posted, if 2 current employees both volunteer for hours or for available hours, how do you decide which employee gets that? So those types of things need to be in this written policy that goes to all existing employees, detailing how new shifts are being offered. And that's actually, we'll get into the penalties a little bit later that are in the ordinance, but this is another thing that is, a per pay period violation, I think. Dan, correct me if I'm wrong on that, but I'm pretty sure this is a per pay period fine if employers don't have this written schedule or this written policy for offering new work shifts to existing employees. Yeah. So, it can add up. And again, it's not one of the, in my estimation, I think it's the only key document anyway that there is not a template available for on the City of Philadelphia's website. So generally speaking, employers must offer any new shifts to existing employees first. That can be done in a notice of available work shifts that needs to be posted for at least 72 hours, so 3 days before hiring any external candidates. The one caveat is that existing employees are not, you don't have to offer these new shifts if it would result in overtime being owed to any of the eligible employees. So essentially, if all eligible employees are already working 40 hours, you don't need to first give them an opportunity to bid on these shifts. So a new employee may only be hired if no employee accepts the offer of available work shifts within 24 hours of the end of that 72-hour posting period. So, in practice, you can't hire externally for a period of 4 days. A new employee may also be hired if the employer receives written confirmation from all eligible employees that they're not interested in accepting the available work shift. So, theoretically, say you post this notice of available work shifts on Monday morning, and by Monday evening, all eligible employees have already said, nope, not interested. Then at that point, have at it. You can go ahead and hire externally. And similarly, you can hire externally if the existing employees have accepted only a subset of the available work shift. So, say there are 2 shifts available and you post it as a notice of available work shifts, and you only get one of those available shifts covered, and you don't have anybody volunteering for the other, go ahead, you can hire externally under those circumstances. So Dan, I think this one's you.
Yeah. And
never mind, Dan. I'm sorry, that's me. I'm trying to.
okay. How dare you? How dare you? Please continue.
I'm trying to shift the posted presentation schedule to you. So a notice of available work shifts has to include a number of things, including the available work shifts or days and times that the employees would need to be available, the length of time the employer needs coverage for those additional hours. So it may be, you need to cover a shift because somebody will be out on FMLA leave for a period of, 12 weeks or whatever it may be. Or maybe it's just, on a go forward basis because somebody quit or resigned. The notice of available work shift should also include a description of the position, the required qualifications for the position, the process by which employees may notify the employer of their desire to work the shifts. And if the notice is being posted for less than 72 hours, you need to give employees, you need to let the employees know that. Essentially, if there's if there is a pressing issue or something like that, they absolutely need to find coverage within 72 hours or in a period of, shorter than that 72-hour period. It's my understanding that you can go ahead and, and still hire externally, but you need to give employees notice and explain what that rationale is. So Dan, now I think it's you.
Thanks, Tim. This next slide just outlines the procedure for offering new shifts. As Tim outlined before, there needs to be a written notice posted of all available shifts. Similar to schedule posting, it can be electronic or just in a physical prominent place in the establishment or both. Naturally, it should be consistent with this written policy for offering and distributing shifts that employees should already be on notice of. And then if no employees respond, or if all the ones it's distributed to, reject the offer, you can go ahead and hire externally. But if one or more qualified employees respond and are willing to take on some or all of the hours, then a determination needs to be made as to whom to offer the new time to. And the ordinance, the regulations to the ordinance, I should say, offer more guidance here. the standard for whether an employee is qualified is that of, again, quoting the regulation, a reasonable employer acting in good faith. So long as you're, choosing whoever's, has on paper the best qualifications, or choosing among those who have the best qualifications, if there's kind of a tie, it's only when the circumstances indicate, a lack of good faith or an unreasonable exercise of judgment. Only in those circumstances is the city going to second guess choices on this. Once the new hours are awarded, it's important to use that same consent form we just looked at to add the hours and to get the employees sign off. And that last box again says, if no current employees volunteer or accept the additional hours within that time frame, then you're free to hire externally. And so that either means you have a 72-hour posting period, and I believe in the language of the regulations, it's that 72 hours plus another 24 hours. So it's basically you post the available shift, and if 4 whole days later, no one's taking you up on it, you can hire externally. If you implement a system where people can either accept or reject it, and all the people or employees rather who have that notice reject it, then you can maybe short circuit that kind of lengthy posting requirement. But again, it requires an affirmative response of some kind, either way.
And Dan, to that point, one question that I've gotten from a number of employers is, during that 4-day posting period, can employers still, kind of get the ball rolling and, interview external candidates, or at least, have a posting out there to solicit resumes or, whatever, just kind of garner interest. So then they're not 4 days behind the ball when they get to that, that point. And, my advice is, I don't see anything stopping you from doing that, as long as you're not hiring externally at any, time before that, that 4 days or any of the other circumstances that we mentioned. So I just wanted to note that that is a question that I've gotten a number of times.
Yeah, and I don't have it in front of me, but I believe the regulations speak to that it's fine to, do both processes simultaneously.
Right.
You're only going to incur a penalty under the regulations if you're awarding hours to an external candidate when you have qualified internal candidates who say, yes, I want this additional shift.
Mm-hmm.
And with that, I think we can turn to the next slide here. This is just at least the top part of the required poster that the city also promulgates. It's on that same site that Tim talked about. We don't like to fill presentations with URLs and things. The city's subpage for this is the first result if you Google Philadelphia Fair Workweek. And the poster again just reiterates what the basic requirements are, some examples of common violations, and it also has a link to the city's unit that enforces the law and links to where employees can file complaints, that kind of thing. So similar to many of the other mandatory posters that you put up in those respects. Finally, I wanted to, before we talk about some enforcement trends, just talk a little about the fines and penalties that the ordinance imposes, because these are really substantial, and they're so substantial that they result in settlements, even in single employee cases that are often higher than your average case. So we talked about good faith estimates at the beginning. If the good faith estimate's incomplete, if you don't have one for the employee, or if it lacks a good faith basis, like the employer who just writes every hour of every day on it, that kind of thing, that's a $200 fine. Failure to post work schedule in advance is a $50 fine, but that's per employee per pay period. And as it's written, that would apply to basically everyone who's on the schedule. So that's a very substantial fine as well. Failure to promptly notify employees of changes to a posted work schedule, meaning within 24 hours, that's a $25 fine per affected employee. Failure to obtain written consent for added work hours is a $100 fine under the regulations. Failure to provide written notice of available hours is a $50 fine. But again, it's per employee per pay period, so it adds up very quickly. Failure to provide written notice of the policy for distributing work hours, also a $50 fine per employee per pay period. So just by not having that policy in place, or having it but not, distributing it to employees, you could be racking up, thousands of dollars of fines under the ordinance, every pay period. And finally, where an employer fails to award available hours to an internal candidate who's qualified, willing to take the hours, awards them to an external candidate instead, that's a $1,000 fine or penalty per affected employee. So needless to say, these fines and penalties can add up very quickly. Some violations are going to trigger multiple categories of those, and many or most of them are per employee and per pay period. So the compliance with this regulation can get very expensive very quickly. So in the time we have left, I think Tim and I want to talk a little about just the enforcement trends we've seen. Tim has dealt more with enforcement trends by the city, while I've dealt more with private attorneys who've been filing these. We've seen a number of class actions against restaurants in particular, not as much against hospitality. Restaurants would probably be number one, retail, second. We just have not seen as many demand letters or claims against hospitality clients. I don't think it's because they aren't happening. It's just restaurants have really been the focus, at least among the plaintiffs bar. And really on the compliance side, some of our clients know nothing about the ordinance, have made no efforts to comply. Some are trying to put compliance programs in place, and some, have reasonably compliant programs and are doing the best they can. And essentially in every case, it's a decision of settling early or fighting it out. For employers that have arbitration programs, or if you have employees who've all signed arbitration agreements, that can reduce exposure. At least the plaintiffs' counsel we commonly deal with, they aren't interested in fighting about arbitration. They'll file, single employee arbitrations in cases where we've presented them with arbitration agreements. And while that still involves some expense, the exposure is limited because you have one employee proceeding before an arbitrator rather than hundreds, proceeding in court. The settlements, as I said, are often quite high and higher than you would see in other, kind of single plaintiff or, de minimis or nuisance value kinds of cases. We've even seen, in some smaller retail establishments, single employee cases that settle in the $30,000 range, which is, really a high number for an ordinance violation. But Tim, maybe you could speak more to what you're seeing on the city's end in terms of enforcement.
Yeah, sure. So undoubtedly, I think dealing with a city enforcement action is going to be much less stressful than dealing with, a plaintiff's attorney on the other side. Basically, the universe of potential violations, fines, etc., is pretty much the same. A large factor that you don't have when dealing with, a potential cost of a city investigation is attorney's fees. You don't have the specter of having to pay, hundreds of thousands of dollars in potential attorney's fees when you're dealing with, the city. In my experience, obviously full compliance with the ordinance is great. It's probably the gold standard. It's not, at least based on what we've seen so far, it's not necessarily what's happening. It's not practical really at this point to be 100% in compliance. Although, I think we can certainly get employers there. But what the city, in my experience anyway, what the city wants to see is at least some sort of, attempt at compliance, some sort of good faith, attempt to, have good faith estimates, post the work schedules, do your best with predictability pay. I mean, I think when dealing with the compliance aspects, the low-hanging fruit anyway is it's going to be the good faith estimates, which are essentially forms. You only got to do them once for the covered employees, get them done right, and then they're there. And then posted work schedules. Get that 14-day notice out. And I think if you're doing those things, that's a lot of what you need to do. So from the city's perspective, even if you're doing those two things, not to say you shouldn't be doing the other things because you should, but or at least trying to, if you're making that good faith effort to comply to some extent, that goes a long way in my experience when dealing with enforcement actions from the city. It doesn't mean you're just going to get off scot-free with a slap on the wrist. You might still have some fines, some penalties. But the city is the investigators are very cordial. There's always the offer out there for employers to to do a city sponsored training on the ordinance. The resources are out there. So again, it's obviously something to be concerned about when you get an enforcement action from the city. But I think if you're taking steps to at least comply to some extent, goes a long way. It seems like the way that enforcement actions get directly to the city are through employee complaints directly to the city of Philadelphia's Department of Labor. Unfortunately, the city of Philadelphia also includes a Fair Workweek complaint form right there on their website. That is, a fillable PDF form that so makes it very easy for employees to complain, and I think that's by design, obviously. So that's kind of how these complaints turn into investigations, from the city perspective.
Yeah, and one other point I wanted to note about enforcement is there have been challenges to the law, and it's kind of enforceability is, at least in our view, an open question. We're representing the Philadelphia-based locations of one major restaurant chain in the Philadelphia Court of Common Pleas. Most of these actions, settle at some point or another, either in mediation or privately. But we have one of the actions that's gone a little further. It is in state court, in the Court of Common Pleas, and we filed preliminary objections, which are Pennsylvania state court's equivalent to a motion to dismiss, on a number of grounds, kind of attacking the ordinance. The main arguments being that it exceeds the city council's authority under Pennsylvania's Home Rule Act, and that the fines and penalties it imposes are unconstitutionally excessive. The city of Philadelphia actually just intervened in that case to kind of join with the plaintiffs, and we're briefing the merits of those arguments now. And if all goes reasonably quickly, we should have a decision from the trial court at some point in the summer on the constitutionality, enforceability of the ordinance. So just one other element in the mix that I wanted to note for everyone. But Tim and I are here. We're at your disposal. We're happy to answer any questions you might have about anything we've been talking about today.
Dan and Tim, thank you both very much.
Thank
I thought
you.
that was a great presentation, and very, very comprehensive. And we very much appreciate you both being here today and sharing your time with our members. I think you covered this ground towards the end, and want to give our attendees here some time to maybe throw a question or two in the chat if you guys have any. If not, I think, Eric, maybe we could go back to the first slide if you're able to do that. I want to say Dan and Tim had included their contact information on that first slide, and so I know some folks are sometimes a little more comfortable reaching offline. A question I had for you though, in the meantime, Dan and Tim, like I said, you started getting into this towards the end about common infractions and violations you've seen. I mean, what would you say arguably is the most common? What do you, in terms of a temperature check right now, what's I hate to say trendy, but what's unfortunately trendy right now in this space?
So I think you can kind of take each of those three buckets, and it seems like there are kind of compliance mistakes in each of those three facets of the law. But I mean, I certainly see an issue with good faith estimates either not being completed completely or not being completed correctly. One of the things that I see on the good faith estimate itself is, when you're filling out that average number of hours, a lot of employers will put a range of hours there, which is, not the regulations actually say you can't do that. Sure. So that's one thing that I've seen is just issues filling out the good faith estimates. The other thing is, at least with the policy for offering new shifts, I've seen a lot of employers just, they haven't caught on to that requirement. So I think it's just an issue of being aware of that and knowing that you need to have the policy. I've audited, a few employers that just didn't have that at all. So those are a couple of things that I would flag.
Yeah, I would agree with that. I think the biggest in exposure terms, in terms of just the fines and penalties you can rack up, are that third bucket, with the offering the shifts and having that policy and distributing the policy to employees. But good faith estimates are tough too. And we get a lot of questions even from, large and sophisticated employers about things like, can I put a range of hours? And, no, you're supposed to just put a number. And when do you need to issue a new good faith estimate? What counts as a significant change? And the regulations go into more detail, but in general terms, it's like a 20% difference. If the hours are varying, more than 20% from what's on the form, or your start and end times are varying by like an hour or more, then that's a circumstance where you should look at issuing a new good faith estimate. But the level of detail and the paperwork requirements, we recognize it's pretty intense, and a lot of employers stumble, in the weeds of those.
That's helpful. Thank you. I don't know, anybody want to come off mute and have any questions? Or thank you all for joining us. Tim, Dan, want to be cognizant of your time, and I know we're rounding out the hour here. Really appreciate you being here. Again, I'd encourage you all to check out Tim and Dan's contact info on the chat here. Friendly reminder, this recording will be distributed to membership. Oh, I do see a question just came in for you guys, Dan and Tim. If any employee stays longer than their shift, are employers required to pay predictability pay?
So from my perspective, I think that's going to depend on whether or not that's an employer initiated change or if it's, the employee just kind of hanging around. But if it's a situation where the employer, say the employee is supposed to work until 8 o'clock at night and we say, hey, can you hang around for an extra hour? In that situation, yes, predictability pay will be owed. If it's, the employer is saying, we need you to stay longer.
Oh, look, we're getting all kinds
How much is that predictability pay? Is it half their rate, or is it a full rate of pay?
Yeah, it's
I think
half the rate, right, for hours that are reduced or added.
Right.
And then I see another one in the chat. Let's see. Does the policy require signed acknowledgement, or is posting the policy sufficient? I think we like signed acknowledgements just because, as attorneys, we're litigation minded and we want to have signed acknowledgements to present to the investigator or opposing counsel if it comes to that. But if you're using some kind of electronic system and you have, a record that you file away that shows it was distributed to everyone, that could be sufficient. But if you're able to do a signed acknowledgement, that's always preferable, because the last thing you want to do is comply, but not maintain, evidence to show you complied.
Thank you, Dan. Thank you, Tim. Thank you both, and from the team at Jackson Lewis. Greg, I see you're coming off mute. Did you have another question?
Yeah, I'm sorry. Thank you, gentlemen, for definitely providing this training. I mean, it's very, very informative. I definitely have like a unique question, and particularly towards like the housekeeping and cleanliness side of house. So if we request an employee to come in on a day off, we ask them to come in on a day off, they volunteer to come in, and they decided to stay. We needed them to stay an extra hour to complete extra rooms, but we pay them the extra credit incentive. So we offer them more than the sufficient amount of rooms at a bulk rate. Do they get paid predictability pay as well as the extra credit incentive? Or would it be a voluntary thing where they volunteer to come in and then they volunteer to purchase extra rooms?
So I'd say if it's an employee initiated change, that would be an exception to the predictability pay requirement. Like if you have a housekeeping staff, right? And keep me honest here, Tim, but if you have a housekeeping staff and you tell them all, hey, we have extra block of rooms that needs to be cleaned, here's the incentive pay rate, and whoever takes it, takes it. I don't think that's a situation where you would owe the predictability pay. But
if it's offered to all eligible housekeepers,
yeah, and
Yeah.
someone just volunteers for it. But if you just tell, housekeeper X, hey, you're the last one who's on, and we have, 5 extra rooms, we need you to handle this, and it takes an hour, then you would owe the predictability pay on top of whatever enhancement. So you have a few options, and one could be, instead of paying an enhancement, just tell them because of the predictability pay requirement, you're going to be getting effectively time and a half anyway, right? Because they get whatever you'd pay them ordinarily plus half that again in predictability pay. that might be incentive enough for them. So hope that answers your question. And again, our contact info is up here if you have any follow-ups.
I appreciate that. Thank you, guys.
Sure. Thank you.
Dan, Tim, thank you both very much again. We appreciate you being here, sharing your time, and all this educational material with and these resources with our membership. I hope we can stay in touch moving forward, and looking forward to continued collaboration with you all and the team at Jackson Lewis. Thank you all for joining us. A recording will be distributed to all that registered and to our membership later today or tomorrow. Thanks again. Appreciate it.
Thank you so much. Appreciate it.
It's a pleasure, Zach. Have a good one.
Take care.